Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. I'd like to talk a little bit today about unlawful presence. Now, this concept of unlawful presence has been out since IRA passed in 1996, so it's been some time. It's been 23 years, okay, since this topic has been out. Now, since it came out up until basically the present, if somebody was here on F, which is student status, J-1, various types of trainee status, or M, which is vocational student status, and their status expired, they would not uh, they would not accrue unlawful presence dates. Okay. Basically, when they came to the U.S., they were given the I-94, which is the document immigration gives everybody upon entry to the U.S., which of course is done electronically these days, but they still, do it. And the fact is that it says D/S as to when their status expires. So D/S means duration of status. So because there was no absolute date set as to when their status expired, they said, okay, these people do not accrue unlawful presence days. So the reason that unlawful presence is important is because when you are unlawfully present for more than 180 days and leave the US, then you are subject to a bar where you can't get back for 3 years. And where you are unlawfully present for more than a year and leave, whether voluntarily or involuntarily, you can't come back for 10 years. So in the past, since these people, the F and J and M status people, didn't accrue unlawful presence, we were able to do all kinds of things in which to help them obtain the green card at some later point. For example, persons are here on F status, school ends, they stay here, they go out of status. Now, going out of status and having unlawful presence are two different things. So, for example, with the F, they didn't, let's say they didn't qualify to adjust status in the U.S. So we would do the consulate processing, whether it's through marriage or whether it's through employment, whatever it is. They would go there, and it didn't matter that they were out of status for however long, they weren't subject to the 3 to 10 year bar, would get their residency and come back. Well, as with many other things these days in immigration, USCIS has now put out a policy memorandum saying that's going to change. They basically say in August of 2018, the new policy will take effect. And what this policy is that no longer will F, M, and J status people who are out of status not accrue unlawful presence. In fact, they will start accruing unlawful presence, and the policy memorandum that they put out lists the various ways upon which they will accrue such unlawful presence. So now, whereas there was sort of a safe harbor, not sort of, there was a safe harbor to try to work with the F, J, and M people who went out of status, that does not exist anymore. And because of that, they're not going to be able to just go out of the country and turn around and come back, whether it's through a consulate processing interview or some other manner. It does make things more difficult. It also brings into question what happens about the people who we've already put into play to leave to consular process. At the present time, there might be an issue of retroactivity. There might be an issue of bringing, lawsuits for, on one day interpreting it one way and then completely doing an about face on another day. But at the present time, I would not now send anyone outside the country who is on FM or J and has gone out of status in the hopes that they can just turn around and come back, because now they will be subject to the 3 to 10 year bar. And then the question is, when does the starting time of unlawful presence begin, under what circumstances? It's still a little different than a regular, for example, B2, which is visitor, or other status, because then you know the exact day that unlawful presence begins. I can tell you that pretty much they're not giving any leeway at all. So if you're in school, for example, under an F-1, and your school ends on May 30th, come June 1st, you're going to start accruing unlawful presence. No grace period, no leeway, nothing. So, the theory that they use behind it is they want to decrease the incidences of unlawful presence, and this is one way they're going to do it. The reality is they just keep chipping away at item after item after item, basically to make it more difficult. But we review the regulations, we see exactly what they say, and we work accordingly to help. So if you have questions, give my office a call. If you like the video, click like, subscribe, and more on the coming videos.